Hello, and welcome back to the Argyle CIO Leadership Forum Vision Strategy Trends. My name is Vicki Lynn Brunskill with Argyle. It's great to have everyone joining us today. I have some important information to share with you, and then we'll turn the floor over to our esteemed keynote speaker. First, a quick reminder to stop by our sponsors' virtual booths at any time during today's event and for the following week. Our partners are committed to providing you with valuable content and a great overall experience today. And to ask questions throughout the sessions, simply type into the Q&A chat and we will address your questions at the end of the session or in real time if they're applicable to what is being covered. And now, without further ado, I would like to introduce our speaker, Scott T. Lashway. Scott is a partner at Manat and co-leads the privacy and data security practice. We are so excited to have Scott with us for his keynote presentation titled Compliance Alert, IT Legal Update for CIOs. Welcome, Scott, and over to you.
Thank you, Vicki Lynn. It's a pleasure to be here this afternoon. And so thank you, everyone, for listening in. Just a quick programming note, I'm happy to take questions through the chat function to the extent it's working for you and for me in real time. I'll try to address them as I can and as they stream in. Otherwise, we'll save some time at the end of the discussion to respond to as many as possible. And if I don't get to respond to your particular question, or if you have one that you don't feel comfortable asking, you can always find me after today's program. So I'm going to try to provide all of you just an update about the world in which you live from a lawyer's perspective. Often I am asked by folks who don't do what I do, what's the role of a lawyer in the world of technology where the CIO or the CTO is making all of the critical decisions? And unfortunately for your positions, you have more responsibilities on the legal side or the compliance side of the world probably than ever before, as the law tries to keep pace with technology development, data proliferation, from data manufacturing to transmission, collection, and storage globally, and then all of the risks from your routine thieves to the geopolitical climate in which we find ourselves, in particular here in the West, where you all are at the front lines of geopolitical risk and sometimes warfare. So with that, let me jump into the substance, and I'll try to make this as practical as I possibly can in 30 or 25 minutes or so. So what's new? Well, things are changing quickly. We've got new privacy laws that have received a lot of attention, both in California, but elsewhere, in Connecticut, Colorado, Utah, and Virginia. In California, we've already amended the laws there with the CPRA, which is an amended version of the CCPA coming out on January 1st. Those laws often include not just privacy restrictions, but also what I would describe as very broad security expectations, at times using language like reasonable security measures or adequate security measures, similar to what you would find in the FTC's regulations in Section 5 of the FTC Act. We also have implementing regulations coming out from California, with the most recent version coming out this past week, in Colorado issuing recent implementing versions of the law, which are profoundly concerning in how we handle and transmit data in the systems that we use to do so, both at a corporate level, but also at an employee level. We have additional security incident reporting obligations, meaning when risk materializes, the pressure is on, and typically on for the legal group, working in conjunction with security privacy in the CIO's office, at a staggering pace to figure out what happened, how did it happen, and are there legal obligations that have been triggered under statute or contract. And of course, you have continuing pressures on the technical development with some of the things we mentioned here. Now, this is all in the context of, one of the most routine now top risks at most companies of whatever size and whatever industry being reported by CEOs as cyber risk. Yet your budgets haven't necessarily increased sufficiently. your personnel haven't increased sufficiently, and the sophistication and experience on your teams hasn't increased sufficiently to keep pace with the internal demands and the external risks. So what else is new? So we also see contracting counterparties, both vendors on whom we rely and vendors that we sell our products to, expecting security and privacy to be at the forefront of the material terms of contracting expectations. And the contracting generally, in my view, has gotten pretty sloppy. So things where lawyers will turn statutory obligations into contract obligations can be particularly concerning if you're a CIO. So here's an easy example. Under HIPAA, there is no private right of action for mishandling data in violation of HIPAA. Where HIPAA is enforced generally is through the Office of OCR at the U.S. Department of Health and Human Services, and through state attorneys general, which generally can bring civil actions at times. But all too often we see contracts turning HIPAA obligations into contractual obligations, meaning now if you have a violation of HIPAA, the counterparty arguably has a right to enforce those contractual terms, whatever they may be, through that contract between you and the counterparty. In effect, you've increased your material risk significantly and exposed the company to potential litigation where otherwise that risk may be somewhat minimal. That's only increasing your overall legal risk in the CIO world, and it's something that's being done at times without a full understanding of what those risks are and aren't. Then we look at where the vulnerabilities are and what keeps maybe you up at night and what keeps your general counsel up at night, not always fully understanding the technical landscape as you do. And we've seen repeatedly significant vulnerabilities being reported in the United States, even with the better and more informed resources that are now available to routinely report significant vulnerabilities to allow your teams to get attention. With that better reporting, our adversaries who aren't always in the West have the ability to exploit vulnerabilities on rapid pace and at significant scale. Things like the cloud have both provided you an opportunity to scale your businesses, potentially reduce costs, and at times outsource functionality like privacy and security controls, where you otherwise would scrape to find the necessary talent, engineering, and be able to afford that. But on the other hand, it exposes you to potentially wider scale attacks when vulnerabilities in that cloud application or utility is exposed outside of your control, and you're left having to rely on the cloud service providers to respond appropriately and respond to your questions. So where does cyber legal risk come from? It comes from all over the place. I mentioned statute. We have both federal and state laws. We have contract that I briefly described, and we'll get into some of these in more detail. And then we have tort, which we'll talk about a little bit as well. Tort are things like negligence, fiduciary responsibilities, which if you're a executive at a company in most states, you would have by common law. And then we have a mix of regulatory guidance and industry standards that are frequently baked into our public disclosures, our contracts, and at times our marketing materials, such that consumers and those who are out consuming our products and services will argue or could argue that they're relying on, say, your compliance with NIST or your compliance with GDPR, even if it doesn't actually apply in the particular situation. And that reliance could potentially expose the organization to legal risk at the intersection of technology. So if you take a step back for a second and think, well, geez, this is quite a soup that we've made for ourselves. The answer is yes. And how do you get yourself out? One of the most important things is making sure your counsel, both inside and outside, understands your program, your strategy, your objectives, both tactical and strategic, in trying to address legal risk and making sure that they're owning some of that decision-making themselves, along with other constituents within the organization. And it's gotten more complicated. So an easy example are state breach notification laws. They've been around for a long time, dating back to the mid 2000s. For a long period of time, compliance with them during a data breach was somewhat of a mop-up operation. So after you were done with your thorough investigation and your forensic vendor and whomever else was involved, along with your outside legal counsel who specializes in this space, you'd make a determination with facts that weren't always perfect, but were close enough for you to make a decision about whether a breach notification was required. Today, with respect to those laws and the technology you're using, it's become increasingly difficult to determine, is this a data breach or not? And it's one of the many reasons why you see more lawyers in the space, not all of whom have all of the experience you would want as a CIO, but who are there to try to assist in making these difficult legal decisions based on the factual development that you and your teams assist with greatly. And if you want a recent example of the complexities here, the New York Department of Financial Services, which regulates financial entities licensed to do business in New York, ranging from banks to insurance companies to vendors who are supporting them, just announced this past week a $4.5 million fine to a healthcare company when they found that the organization was not in compliance with their quote unquote cyber rule, or 23 New York CRR Part 500. It's worth reading that if you never have. And the fine was $4.5 million, which is not chump change. $4.5 million in the litigation context in a privacy class action still is a pretty significant settlement these days. We're seeing regulatory fines increase. We're seeing regulators generally have some unwillingness to resolve matters as they once did, quietly and for cheap dollars. And they're looking to make examples of companies who are not necessarily fully complying with their either view of the statutory obligations or consumer protection laws. And states are trying to force better cyber resiliency. So we have a private right of action in the California privacy law, which is obviously an industry agnostic law focused on consumer data. And the trigger there is reasonable security. Now, of course, reasonable security would be viewed by a litigant there in hindsight. So if you have a data breach, they clearly would argue that your security must not have been reasonable. Otherwise, you would have prevented a data breach. In Ohio, just a couple of years ago, they built what we would call a safe harbor under the law, looking to minimize or reduce potential liability if the company had mapped their security program to a framework like NIST 853. And then in 2017, as I mentioned, New York's financial service regulator, which regulates entities both within New York and extraterritorially, adopted what we call the cyber rule, which in the US, I would argue is the most sufficient and widely applicable set of regulations with respect to managing cyber risk from a very tactical perspective. In addition, a lot of companies and a lot of CEOs would look to their risk department or their legal department to say, well, I'm not going to be perfect. I don't have nearly half the budget I need or the personnel. So let's make sure we have appropriate cyber insurance. The cyber insurance markets, largely due to the recent proliferation of ransomware attacks and the costs associated with responding to them, have dried up a bit. And it's probably not such a bad thing, but cyber insurance is not the game that it was, say, 5 years ago to cover all of your privacy, security, and technology risks related to the proliferation of the threats that we've been seeing. So I just got a question: what should an organization do to navigate laws across the US internationally? So the first is have capable legal counsel who specializes in this space, who understands technology, can have a conversation with you, at least at a level where you don't have to explain what a firewall is, so that they can help advise you where the laws would apply, how to assess the risk around those laws, how to ensure that your business objectives are compliant and can grow within those laws and obligations, and then how to reduce the risk as appropriate and when capable. This idea of saying, well, the law says you can't do that, that doesn't really work. And so lawyers need to, and your lawyer needs to, and I would demand of that person to be able to assess risk with you, understand your business needs, your technology needs, and advise where the law is applicable and where risk can be reduced. So some general causes of action we see, and these are things for you all to keep in mind and to have conversations with your respective lawyers about this. But we know about the statutory laws like the CCPA. You can't go a day without reading a new legal blog about the CCPA, this, that, or the other thing. But things like negligence, fiduciary duties are really important. Do we have a duty? Are we meeting that duty? Are we causing harm? Are we doing so intentionally? If so, let's make sure we're speaking with legal about appropriate measures that can be taken to minimize the risks of these types of lawsuits. It's similar to putting that security side out in your front lawn. Whether your security system is set up or not, you want to deter someone from entering your part of the building and keeping them moving along, and that gets you partway through meeting your legal responsibilities. The other thing you want to be focused on is overall decision making. So there's a number of laws out there, a number of cases out there in which courts are looking at management and boards of director and opining that the fiduciary responsibilities of management and boards apply to cyber and privacy risk, that you need to have sufficient reporting internally, that reporting on pings and defenses isn't sufficient. You need to report on wins and losses. We had an incident. This is what happened. This is how they got in. This is how we're going to make sure they never get in again. Those types of conversations under legal privilege are critically important to protecting individual decision makers within organizations. And the board, of course, is more focused on this than ever as litigants attempt to increase settlements by going after board members, and the program built to have the CIO, or typically more appropriate, the CISO, the Chief Security Officer, reporting to the board directly on security risks. The SEC, of course, doesn't want to be left out. They're requiring and are going to require reporting obligations that arguably would potentially expose companies to greater risk. This idea that we have to provide immediate information to the investing public about what could be an ongoing security incident is extremely dangerous. It's extremely dangerous, as you all might know. If you're dealing with an incident, it often takes days, weeks, or months to figure out what's happened. And having reporting obligations potentially triggered during that time period can be very complicating to your efforts to protect the organization and its assets. And of course, one of the most important things you can be doing is making sure your decision making during an incident is protected. And this is not the reason to involve lawyers, but this is a benefit to involving lawyers in your security and privacy programs. And that really starts with your development of the programs from a technical perspective. Asking lawyers, how does the implementation of this tool potentially reduce our overall legal risk, and the matrix that would result in legal risk is a critical discussion. I'm going to stop here and take a few questions as I quickly running out of time, and the slides are available through Argyle if you'd like to read them. There's a number of slides that keep going, but ultimately you need a team around you. So CIOs no longer should be responsible for security or privacy. I would argue that most organizations, those responsibilities should sit outside of the CIO's office to ensure that you don't have the fox watching the hen house type approach. It helps minimize fiduciary and negligence claims immediately by just having the appropriate structure. Obviously, security, privacy, legal, compliance, risk, HR are all at the table when dealing with security and privacy risk, both proactively and reactively, involving those constituents in assessments of any kind, in maturation discussions, in bi-weekly program discussions and risk mitigation efforts is really, really helpful. Understanding what's going on in the employee base and what's going on in the legal world can be critical to help you all fulfill your responsibilities so that people can sleep at night. Let me go through a couple of these questions. Which types of IT-related non-compliance issues are landing enterprises and courts most often? Right now in the privacy space, we're seeing a lot of cases related to website and data collection practices. Plaintiffs' lawyers have woken up to applying laws from the 1980s, like the wiretap statutes, both state and federal, which often, or in some states, require two-party consent to record a conversation, to say, you're recording information without my consent, sometimes behind a paywall in violation of this state wiretapping statute or that state wiretapping statute. It's become very prolific. I don't know how economically beneficial it's become to the plaintiff's bar, but they're filing a lot of them. Biometric data has been a leading cause of action in Illinois courts, for example, for years since they passed their BIPA law. This relates to the collection of biometric data, retinal scans, thumbprints. There's lots of uses now within the employee space to collect that information. And there's something like over 200 lawsuits pending now. So those are two examples. You know, we've gone from cookies to pixels in the website tracking space. And so litigants are going to continue to focus there. And then there's just the old school corporate espionage, where, you know, an employee goes from one to another, or someone leaves a port open and a competitor comes in, steals a bunch of data. It still happens routinely, including in violation of sometimes federal criminal and state laws. But it hasn't stopped folks from doing that. So we see a lot of activity in that space. Is there a service that continually updates the state data breach requirements? There are. I think the challenge there is not what the requirements are. It's understanding the strategy to comply with your security and privacy legal obligations. So ask your lawyer who needs to be trained in this space. If you have a tax lawyer, they're not the person to ask. What is my potential legal risk? What laws should I be concerned about? And what, if anything, can I be doing to ensure that I'm mitigating my risk? Privacy, for example, an easy way to mitigate risk is understand what data you're collecting and you're using, you're transmitting, understanding how you're doing it, and then understand what the law requires of you. Typically, disclosing what you're doing to the individual that you're collecting data from goes a long way in reducing your overall privacy risk and your litigation risk around there. Is there a resource online where we can track significant changes for IT related compliance? I'm not aware of one. There is no shortage of ink spilled on a computer screen, blogs about, you need to do this, you need to do that. I find the challenge with all of the writings is that a lot of it's noise, and sometimes it's frankly straight up wrong. We see people writing about new statutes or new regulations that seem to be completely an opposite of what the statutes are actually saying. And then that gets proliferated from one blog to the next. So I'm not aware of a source for tracking significant IT related compliance. I still think we're in a position where finding a good resource in the form of a human being is going to be cheaper and more beneficial than something you're going to be able to read. How do companies, as an example, not-for-profit organizations, get a good place with cyber compliance? Cyber insurance is a requirement, but the risk tolerance versus funding becomes an issue. I think relative to cyber insurance, you need to understand what you're insuring. We see a lot of organizations go out and they went out and got cyber insurance because they were contractually obligated to do so. So for a nonprofit, for example, they might have been contractually obligated relative to a significant contribution to the nonprofit. That's fine, right? But that doesn't solve your cyber risk. If anything, that gives you a little bit of comfort on the tail of that risk should anything ever happen. But even should something happen, it's not necessarily true or expected that the cyber insurer is going to kick in. And so I think what you're better off doing is trying to assess on the front end what that risk might look like. That doesn't need to be a remarkably complicated or sophisticated exercise. You just have to find someone who knows how to do it and is willing to do it efficiently. Unfortunately, in the US, there's no shortage of marketing in the cyberspace. There is a shortage in the talent in the United States with respect to people who have experience in the space. But find a good one, ask your lawyer if they have one that they could recommend, chat with those folks. Oftentimes, especially if you're a nonprofit, people will want to help who do this work. And if you want to follow up, I'm happy to provide more details and any referrals that I can within my network. So with that, Vicki Lynn, I think I'm out of time, although I could obviously keep talking about this for another 3 or 4 hours.
Thank you, Scott. We wish we had time for you to do so. And thank you everyone for attending this excellent keynote. What a practical presentation. I'm sure you'll get some follow-up, Scott. This session, along with all of today's content, will be available on demand following the event. Thank you again, Scott.